How may I approach? We have a
revoked for a misdemeanor case. His bond was revoked at first appearance. That case has been since dismissed, so we're asking the court to reinstate his bond in the county of Okaloosa for over 20 years of his life. I think the case before the court is taking a deer at night, possession of a convicted felon. I think the allegations are he's on his property shooting a deer, and then there's another theft case of a deer camera. I think the allegation is was on an adjacent property. So, not a violent offender, not a serious threat risk to the community. We're just asking the court to reinstate his original bond conditions.
What does the state say?
Your Honor, indeed, the grounds that caused the revocation of bond in this case, that case was dismissed. So I don't have a reason to object. However, I would ask the court to impose a heightened pretrial services, a weekly in-person check-in, and weekly urinalysis.
Well, I'll reinstate it with a weekly check-in.
Thank you, Judge. I appreciate that. Judge, thank you very much. Enjoy your day. Good seeing you.
Thank you. We have Zachary Johns. Do we do that? Yeah. Was this where Kilpatrick was not here?
Judge, this was the defendant who was in the Santa Rosa County Jail. He wasn't transported. So
Yeah.
there was a second transport order that you just signed. So I think they just transported him over early for the 6/6 hearing.
Oh, okay. So he doesn't actually have a hearing today. And Jason Miles. Y'all heard from Mr. Powell?
It's my case, Your Honor. No, I have not heard from him.
We have a VOP evidentiary hearing for today.
I don't believe it's an actual evidentiary hearing. I think it's a status. There is a plea offer on the table, but I haven't communicated with him.
We'll bring him back this afternoon.
It's Dixie.
Dixie, oh, okay, never mind.
Luis Lopez with Glenn Switek. Bring him back this afternoon.
Out to Mr. Switek to see if we can provide him some additional discovery that I had asked him to do.
Timothy, is it Gajek? Gajeka? Timothy Gajeka. You are here, Mr. Gajeka. This is 20 CF 1652 and a violation of probation. Is there an offer for him?
He actually was issued a notice to appear, and probation this morning verified the only outstanding requirement is his interlock device. They went out and confirmed that's on his vehicle, and he has completed everything else. Probation has expired at this point, so we'd ask the court to dismiss the vehicle.
All right, do you have any objection to me dismissing the VOP?
No, sir.
Okay, I'll dismiss it.
The interlock is currently in his vehicle right now. I've verified
All right,
myself.
your violation is dismissed.
Probation dismissed also?
And probation terminated.
Terminated?
Hold on. Wait.
He doesn't have a black robe on.
I'm sorry.
Yeah, I'll terminate the probation.
Thank you, sir.
Okay.
I'll finally see you. Thank you.
All right. Ammerman, David Ammerman.
Your Honor, I represent Mr. Ammerman, 19 CF 1998. Tim Gibbs on his behalf. Judge, he's in the state hospital after being found not competent to proceed. We were set for today for a status hearing, basically a 6-month review. I only just got a report from the state hospital yesterday saying that he is still not competent to proceed. They also believe that he's either coming up on his 5-year track rule for potential dismissal for non-restorability. So I think we probably should reset this for sometime next month to try to get that, get him set for a hearing on that issue of restorability. That's what the report is recommending.
State has no objection.
What about June 6th? Is that too
That
soon?
might be too soon to have him transported.
June 27th?
I think that's the next available that we have.
June 27th?
Thank you, Judge.
Okay. Brackero,
Mr. Sakima Bracero, Judge.
Cero?
Your Honor, Tim Gibbs on his behalf, Judge. This is 21 CF 984. It's a similar situation. He's set for a 6-month review today for competency to proceed. I have not received a report. I'd be okay to reset this one to June 6th to try to get that report from the state hospital.
No objection.
All right, June 6th. I don't think I've received,
I'm sorry, Your
I
Honor.
don't think I've received any of these
I
reports.
haven't seen any reports from Mr. Bracero yet, so we can certainly try to follow up on that.
Patricelli, did you have any more, Mr. Gibbs?
I have more inmates, Judge, this morning.
All right.
I'm happy to wait. The court wants.
Patricelli,
Your Honor, the state has made a new offer. I'm going to convey it to her. Your Honor, I'm going to ask to bring her back after lunch. Give you time to think. Oh, okay. Well, if we could just give us a few minutes, Ms. Basso. Yeah, Yeah, I'll come see.
Lyndon Patrick. We know anything about Glendon Derek Patrick?
Your Honor, he was on the docket the other day, and he failed to appear then, and the court issued a capias. And when it was on today, it made me wonder if maybe he had had contact.
I'm sorry, he wound up showing up
Okay.
Tuesday.
Okay.
So we took care of it Tuesday? Okay.
Oh, we told him to come back
Told him
today.
to come back today.
I know he came in Tuesday. I'll try, Your Honor, if we can pass him for a second, I'll try to get up.
All right. Joshua Pellegrino?
Your Honor, Mr. Pellegrino is present. He has come from the state of Michigan.
All right.
Your Honor, the last conversation I had had with Ms. Glisson that she had conveyed was if he paid restitution, the state would terminate, and I did speak with Mr. Sprouse regarding that as well. He has the money orders here for the restitution. I've showed it to Assistant State Attorney Sprouse. The issue he had in trying to pay it is his probation officer would not take it and said it would have to be paid through this case and another case. And I'd spoken with Mr. Berry, and he said there is a way to handle that to where it goes on his case. However, they would not do it. So he is here in hand with the money orders to pay that restitution to close out his case. Any help?
Well, how do we normally pay restitution? Doesn't it go to the clerk or something? And
Your Honor,
They don't
from
do that anymore.
State probation's perspective, I don't know who told her, Ms. Rivers, this. She has talked to me. I know how to do it. I'm not his officer though. But if you have several different cases open in several different counties and paid $100, then each case would get some money. There is an override system. Everybody that works for us knows it. Why they're telling her they can't do it, I don't know, but we can do it.
I mean, when I order someone to pay restitution, how do they do the restitution? To get credit, doesn't it go through the clerk's office?
Used to, then it started going through JPay, and now my understanding is it's going to go through something else.
But, Your Honor, for the record, it's my fault. I was late in paying the money. That's why I wasn't able to pay it when it was time to pay it, because of the probation had exhausted. Therefore, when they tried to click on it at the clerk's office to open up the case, it would not open up. So it was my fault for not paying the money in time.
So how does he,
So if it's past the termination date, I think he would be able to pay that through the clerk, wouldn't he?
Clerk's office.
so can he pay it through the clerk now?
I tried to pay it through the Target in Destin. I tried to pay it through Walmart here in Crestview, and they couldn't take it. I talked to their restitution company, and they couldn't take it as well. So
Who's it go to, Target or Walmart? How much is it?
Your Honor, it is $446 to Walmart, and Target is $1,036.97. He has money orders in hand.
And
So would the clerk
clerk
possibly
won't-
take it?
the
'Cause
clerk won't take it because it's made out to these, the clerk won't take it? Yes, Mr. Sprouse.
What if we, I don't know, put him on a short term of admin probation and then order the clerk to take the restitution? There has to be a way for him to pay restitution. That's why he came from Michigan.
Yeah.
That is a bunch of work. Right now,
And you went to the Walmart and the Target to pay them, and they wouldn't take the money?
yes, Your Honor, I talked to their restitution company. They sent me to a third-party company, and it was just a big mess. The main thing was I spoke to the probation department in Polk County, who supervises my whole probation in the state of Florida, and I do it in Michigan. I actually drove 16 hours to come here and take care of this. And I just don't know what else to do. The only thing I could do was just come with money in hand, Your Honor, you know, and then I can sign it and leave it blank, and then, you know,
Well, the clerk won't take it. The victims won't take it. It looks to me like the victims are waiving the restitution. I'm just going to enter an order amending his judgment and sentence. Prepare me an order amending is just not requiring restitution. I'll do it that way. If they don't want their money, you know, they refuse to take it, and he's trying to do everything he can. The clerk won't take it. Target won't take it. Walmart won't take it. He's driven down here from Michigan. Then I'm going to let him keep it. And they can file some motion or whatever. Why didn't they get their restitution?
Judge, I got correspondence from our victim advocate. Apparently for the target money, it's supposed to go to their law firm, and we can get them the address to that.
Target money?
Yes, because he owes money to Target and then Walmart.
How much was it to the Target?
The Target was the 1,000.
no, it's this one,
Oh, Target is what?
the 455.
Target, no, that says 455 for Walmart.
No, that's where I got the money.
Oh, that's where you got the money order?
Yes, ma'am.
Okay, so how much is it for Target?
The Target is the 450.
455 for Target?
Yes.
Okay.
Well, is there a law firm for Walmart?
Well, the state doesn't normally ask for restitution for Walmart because they always go after it civilly. So this was like one of the rare cases that it was required.
Walmart typically sends out a demand letter under the civil theft statute where they can request a minimum $500 or triple actual damages. And so I know when I was a prosecutor, I don't think we ever got any restitution request out of Walmart. But they would send out the civil demand statute, and they get attorney's fees on that as well.
Walmart does ask us to get restitution. I want to be clear on that.
Well, then who they send it to? Who's the defendants?
When I've done it, usually we have the clerk as a depository. But this happened before I was on the case, so we never got an order for the clerk to be the depository. That's the hang-up that I thought we had as far as the clerk accepting the money. Now the clerk is asking for a court order to.
All right, well, prepare me an order. Okay, I'm going to change that. He does have to pay restitution, and the check can be forwarded to Target's law firm.
Do we have an address?
We'll get it to you.
And then prepare me an order saying the clerk will be the depository for the Walmart.
Thank you, Judge.
We'll try that. Although the checks are made out to, who are they made out to? Blank? Okay.
Money orders, so.
All right, we'll do that.
All right.
See how that goes.
You're fine, you're fine.
And based on those circumstances, is his probation terminated?
Yeah.
Okay, thank you.
So we don't have to come back here if there's still some issue with all this.
And that was all, wasn't it, Ms. Rivers?
That's all. That's all that was left.
All right,
It was already against his termination date.
probation terminated, so, you know, you may want to keep the receipts or something showing that if they ever try to come after you for it, you can say, I paid it to your law firm and I gave it to the clerk's office.
Yeah, because the restitution in the overseer in Polk County, they may ask, well, why didn't it get paid into the hub? And I'm just gonna say, you can talk to Okaloosa County, and they took care of everything. And I thank you for all the help and patience, Your Honor. I'm sorry for taking so long.
All right. These are your receipts.
Prepare me an order that says something that addresses both these issues, so if he has a problem, he can get a copy of the order and say, the judge signed an order saying that, he showed up with the checks, he presented the one to the law firm, the other was to the clerk of court.
Good.
Do we have the victim information, our clerk can enter it in the exact amount.
I have the address, Judge.
All right, who is that?
So the law firm for Target is 280 Wekivia, so that's Wekiva, Springs Road, Suite 2030 in Longwood, Florida, 32779.
You may want to put the case number on those checks. So that is to who, Target?
Yes, Judge.
Then Walmart, get the clerk the Walmart address.
Thank you, sir.
How much was the Target?
I believe it's 449.
Well, we can't have a believe. She's got to enter an exact
Judge.
amount.
I have in my notes that it is 449 in arrears to Target.
449?
And it was 449 in arrears to Walmart as well. That's,
How come he has a check for 1,000?
I don't know if he has a check for 1,000. I think that's the money that he spent altogether.
No, we have a total of here of $1,486 total.
And that goes to Walmart?
These are all of them together, total.
Yeah,
So
but
$1,000 altogether.
they need to be broken down into the specific
Yes, sir.
victim.
Yes, sir.
Okay, Your Honor, I have it. Target, $449.99.
Okay.
Walmart, $1,036 even.
That's what those checks are?
We, yeah, he's short $4.99.
Look, y'all get this straightened out. I'm not going to sit here and be an accountant. If y'all want if these people want restitution, they need to get their act together, get the address of where the money is sent and exactly how much. And give me an order with this. I'm not going to sit here as an accountant and have the clerk sit here and try to figure out, we're 45 cents short. Well, it doesn't complete the restitution, and then there's a problem in the future. Y'all get this stuff straightened out, or I'm not going to order restitution in the future. They can handle it civilly.
Yes, Judge.
Next case. But I'm going to terminate his probation.
Your Honor, if I did get a hold of Mr. Svitek on Mr. Luis Lopez's case.
Yes.
That's case number 22 CF 1418. He indicated he had received the discovery and he asked if we could move.
You say why he wasn't here today?
I'm not ready on Stanford yet.
No, Your Honor, he did not. He did indicate he was in the process of reviewing what we had sent over.
All right, we'll put Luis Lopez on June 6th.
Thank you, Your Honor. That would be in the.
Oh, we are. I gave it to him. Either one.
And all future restitution, I'm not going to order restitution.
I got to write that one out.
In all future restitution, I'm not going to order restitution. I don't care how much it is unless there's an exact amount and address to the victim. This is who?
Your Honor, this is Alexis Stanford. And I have...
Okay.
Marked it out.
She just has to sign the new offer from the state, Your Honor. All right, so if you just sign it right there.
And this is 24 CF 513, State of Florida versus Alexis Stanford.
Yes, Your Honor.
Is she entering a no contest plea to all four of these charges, five of them?
Yes, Your
Five
Honor.
charges?
Yes, Your Honor.
Ms. Stanford, you want to enter a no contest plea to possession of a controlled substance, third-degree felony, no vehicle registration, a second-degree misdemeanor, failure to have insurance, second-degree misdemeanor, possession of paraphernalia, a first-degree misdemeanor, driving license suspended, a first-degree misdemeanor. So you want to enter a no contest plea to all those charges?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Did anyone force you or threatened you to enter this plea?
No, Your Honor.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to time served on all cases concurrent. 515 court costs, $100
Cost of prosecution.
cost of prosecution, $150 ED fee.
Yes, sir. Yes, Your
And
Honor.
that's adjudication withheld, Your Honor.
Yes, adjudication withheld. Thank you.
Thank you, Your Honor.
Okay.
Your Honor, this is Gregory Spears. He's before the court on 12 CF 1224 and 12 CF 1016. We are here asking the court to set a bond on these violation of probation cases. There's currently no bond. Mr. Spears is basically a lifelong resident of Crestview, Florida. His family is here. He has numerous ties to the community. If the court were to grant him a reasonable bond, he would be able to go and live with his mother, and he'd be able to follow up on any treatment with his medication. And when I had asked him about whether he had any failures to appear, he did not think he had any. And Mr. Spears would also be able to resume his employment. So he's just asking the court to consider granting him a bond.
What does the state say?
Your Honor, Mr. Spears is not entitled to a bond because he's a violent felony offender of special concern. He's facing the underlying in the violation of probation case is home invasion robbery with a firearm and with a mask, and then he committed burglaries of unoccupied dwelling. So per 94806, he cannot be released on bond pending the VOP.
I can't let you out on bond because you're a violent felony offender of special concern, so perhaps you can get your case worked out. Thank you.
Your Honor, this is Bruce Yarwood. He is before the court on 21 CF 320. We are here on a motion to set bond. Mr. Yarwood is charged with violation of probation. He currently has no bond. Mr. Yarwood is asking to be able to get back to his family. His significant other is struggling. He's trying to keep from losing everything that they have. He has ties to the Florida Panhandle. He does not live in Okaloosa County. All of his immediate family is in the Florida Panhandle. He's asking the court for a low monetary bond or a signature bond, even with the GPS monitor. He just wants to be able to get out so he can help his family.
Defendant already had a GPS monitor on his ankle when he got picked up for this violation of probation. So he's not supposed to go to parks because he's a sex offender. The underlying charge is him failing to register in the state of Florida. So he moved to the state of Florida as a sex offender and failed to register. This is his second violation of probation, Judge. So the allegation he goes to the park to the offender statement when he was talked to probation was to hand out puppies at the park. So we don't think he needs to be out on bond. He has a 5-year suspended sentence.
No bond.
Your Honor, at this time, he would like to set his case for a contested violation of probation hearing at the very next available date that the court has.
No objection.
June 27th, is that the,
That's when they've been set, Judge.
all right,
We don't have any before that?
I don't think so.
Okay, June 27th.
No, I don't. I don't have time to subpoena on the 6th.
Thank you.
June 27th. Okay.
Judge Charles Russell, Public Defender's Office. This is Daniel Kilburn. He's number 10 on my docket. Case numbers are 17 CF 3565 and 21 CF 452. We set this for a case management conference to see if we can get all our witnesses lined up. I've reached most of them. There's a handful that I haven't been able to reach yet. So what I had talked to the state about and proposed to do is if we could set it for a case management conference on June 6th, because other than that, the next pretrial conference is June 24th, and you'll have a date in between, except for the 6th. Maybe I can reach the rest of those witnesses, and then we can hard set the trial.
I mean, the next trial term is July 8th, I think.
Right, July 8th and 15th are the 2 trial weeks, Judge.
So what's the problem? Wasn't he scheduled to go to trial this past time?
Yes, sir. But we had some witness issues. The reason I set it for a case management conference today is to see if I can check with my witnesses and try to avoid any conflicts with the next trial schedule. And I've reached most of them. There's a handful I haven't been able to reach yet. So if I can postpone the case management conference to June the 6th, I may be able to try to get a hold of the rest of them.
Well, I mean, don't you just issue subpoenas to them to show up?
We do. And if the court's comfortable with that, then we can go with that. But I was trying to
I
avoid
mean,
any...
we can't schedule trials based on a half a dozen people's, whether they feel like they want to show up or not.
I would issue trial subpoenas anyway, Judge. I was trying to make sure there weren't any conflicts because of doctor appointments, vacations, et cetera.
Well, Mr. Kilburn was, we had him ready to go to trial. I mean, he wants to go to trial. He has a right to go to trial. I'm ready to go to trial.
Yes, sir.
So just, these people got to show up,
Okay.
so.
Do you want to just leave it for a pretrial conference on June
yeah,
24th?
Yeah.
Okay, that's
Yeah,
fine.
He's already was ready to go to trial once, and someone delayed it, so.
That would be me, Judge. One of my witnesses had an issue.
All right.
Okay, we'll leave it for pretrial conference on
Yes.
June 24th.
Your Honor, the state is ready, and I have spoken previously with Mr. Russell. If he's having any difficulty with anyone, perhaps he can let me know, and I might be able to reach out to them. Just wanted
Yeah, I mean, this is, that we're 6 weeks away from trial. How many days trial was this one scheduled for?
Your Honor, exclusive of jury selection, I think we were talking, we think at least 2 days.
2 days?
2, maybe 3. Yes, sir.
Okay, well, he's ready to go to trial. He needs to have
Yes,
a
sir.
trial. It's, we try to, everybody's got some schedule that, July 8th, I might have liked it to have been on vacation myself, but I'm not going to be because I'm going to be here to try this case.
Yes, sir.
Yeah, so I don't know. You got to
Okay.
issue subpoenas. That's why I have subpoenas. Make them show up.
I'll work on it, Judge.
Thank you.
Okay.
Thank you, Judge.
Your Honor, Tim Gibbs on behalf of LaTanya Glenn. Your Honor, she's on this afternoon's docket. Judge, this is 24 CF 944. Your Honor, she's here for arraignment. As the court's aware, I did already send a motion in order
I
to
am
have.
so sorry to interrupt
Yeah.
and everything. I have said non-compliance to the happening that happened.
Ms. Glenn, let me advise the court why we're here first,
It was a
okay?
warning and everything, and I did heed to the warning.
Don't
I
talk
do
about-
not
don't
know
talk about the facts of your
why
case,
it
Ms.
All right,
did
this is
escalate
24
to
CF
what it did
944.
escalate to.
This
If
is
we might approach, Your
arraignment.
Honor. If we might be
Arraignment?
able to approach, Your Honor.
I
No,
would
we don't
want
need
to
to
represent
approach.
myself
sorry.
if I am able to.
Is this arraignment?
This is her arraignment, Judge. We'd like to plead her not guilty. The court's already found her not competent. However,
No,
she does-
I am
or
competent.
not found-
I
not-
am competent.
The court's already filed her.
I am competent. I will not let anybody say that against me. I've been competent.
I'm gonna go to this
I've
one.
been very much competent to the point where I was able to graduate from the University of West Florida.
Okay.
The court has
We're-
already signed
And
an order to
everything,
have
and
her
I have
evaluated.
already
All right.
understood
Plead her not
everything
guilty and I've
about
entered an order
what
to have
has
her
happened,
evaluated.
and
Yeah.
I read
She
all
does
of
want
the
to represent
paperwork and
herself,
things
but
like
I
how
think we
I'm
need her
stating.
evaluated first, Judge.
And it was meant to be a warning and everything. The write-up seems to be like it was somebody that
Okay.
was
Thank you.
someone that was just,
Unfortunately, he's not ready to hear that right now, Ms. Glenn. He's not ready to hear that right now, Ms. Glenn.
All right. We are, Ms. Glenn is, I think I signed an order to have her evaluated.
You did, Your Honor.
And
That's what I was trying to
she's
say earlier.
obviously having some type of episode, and
She does want to represent herself, however, during the conversations, and as you can see how she behaved today, we have a lot of concerns regarding her competency.
yeah, she's not competent.
I don't know if she's even
I-
competent to make the decision
well,
to
yeah,
represent
that's what-
herself.
that's
That's the
what I'm-
concern.
Meant to say. I don't think she's competent to decide whether she wants to, anyway. We'll have her evaluated, plead her not guilty, and set her for August 26th or something.
Thank you, Judge.
That should be enough.
Or you want to
time.
set her for the August pretrial, Judge?
Yeah. Because the doctors take a while sometimes to get
They
these-
can, Judge.
There's no sense sentencing her,
And if we get an evaluation
3
earlier,
weeks
we can
and-
move her up.
and she, yeah.
Thank you, Judge.
Mr. Horn,
It's a bond hearing, Judge.
is this for this afternoon?
No, Judge, it was scheduled for this morning. I filed
Okay,
a motion on it, and we'll just be tracking the motion.
all right.
Judge,
he's
Mr.
on
Horn's
for-
been incarcerated since about April 8th. His current bond, he's got 2 trafficking charges. His current bond is $150,000 total. He advises he cannot possibly make that bond. He's requesting a bail of $5,000. He's currently self-employed. He resides at 6119 Eden Square here in Crestview. He lives with his mother, Sandra Mayhorn. He advises that his mother is 87 years of age. She has diabetes, she has cancer, and he's lived with her, taking care of the house and yard since at least 2019. He advised when we met that he was being treated for an injury to his left eye. He's receiving frequent care by an eye doctor and is on 3 different medications, including antibiotics. At this point, he's blind in that eye. Surgery has been recommended to him, but there are no plans for any surgical intervention because of his incarcerated status. He's lived in this area since 1984. has family in the area and has developed substantial ties to the area, and would request that the court reduce his bond to one that he can make.
Is he here for arraignment on that this afternoon?
This afternoon he is, Judge.
We just, you don't plead him, why don't we arraign him right now?
Yes, sir.
On
I was going to request to arraign him as soon as I finish the motion, but
24 CF 811, you're charged with drugs, trafficking in fentanyl, and trafficking in meth, and appoint the public defender if they're not already appointed, and how is he going to plead to that?
I'm going to plead him not guilty to that, Judge. Request 15 days for any pre-arraignment motions and demand trial by jury.
All right, we'll set him for August 26th.
All right,
Now,
Judge.
what about the bond? Now, what do you say?
Well, Your Honor, the state believes that the bond as it's set is reasonable. He's charged with trafficking in fentanyl that carries a 7-year minimum mandatory. Trafficking in amphetamine carries a 3-year minimum mandatory. He scores a total of minimum presumptive 144 months. The offer is 15 years DOC with 7 years minimum mandatory. His prior record includes 4 misdemeanor failure to appear, and fleeing and attempting to elude, aggravated battery with great bodily harm, possession of firearm by convicted felon, 6 battery, sale, manufacture, deliver, 2 prior, uttering a for check, 3 possession of controlled substance, 1 felony battery, DUI with serious bodily injury, driving while license revoked, grand theft, 4 of them, driving while license revoked, felony, possession of firearm again by convicted felon, and obtaining drugs by fraud. The state believes that the bond as set is reasonable.
Judge, he avers that, or had kind of whispered in my ear as she was talking that, various things she's talking about are 30 years ago. I can place him under oath and I can inquire
He's
of
looking
him.
at minimum mandatory with these, just in and of themselves. That's too much flight risk. I'm going to leave the bonds where they are. Thank you.
All right, Judge. All right, so that's all for us today. I've already arranged you, and I'll be out to see you again once we get an answer to our demand for discovery. Okay. Judge, this is Winston Lanehart. His parents are in the courtroom with us. He was here for a call date to see if we had the conditional release plan yet. I have spoken with Mr. Barnes twice about it. We went over some different things that we wanted in the plan. He was working on it, and then I got an email from him the day before yesterday saying that he's scheduled this week and next week to be out at the Florida State Hospital in Chattahoochee. And I do not have the conditional release plan yet. His parents came in. I spent a good hour and a half or so with them yesterday or the day before, and they're desirous to, since it's going to be a conditional release plan, to have them go ahead or have him released to their care instead of sitting in jail and waiting until Mr. Barnes is able to finish the plan. What I would ask is that we keep it on a short docket and that the court consider going ahead and ordering his release with reasonable conditions. The reason he doesn't have a bond right now is one of the violations, or the new law violation violated his, well, not just the new law violation. He's alleged to have had access to internet. I've spoken with the probation officer. The access to internet involves a smart TV. The probation officer's position is, since the statute says internet and doesn't specify that it be for communication purposes, that even a smart TV or other smart technology in the house that doesn't allow for communication would be in violation of the statute. The parents have apparently interacted, according to them, with the probation officer and thought that the setup they had was approved based on the probation officer's response. This is not a situation where he was avoiding supervision, where he was absconding. The violation, the new law violation involves another failure to register issue, and it likewise has to do with, according to the parents, the tag number for one of the vehicles was put on the other vehicle by mistake by the sheriff's office, so we'll be contesting that one. He's developmentally disabled, has been since early childhood. He can comply, but the smart thing to do is tell his parents what you need him to do, and then his parents will kind of shepherd him through it.
Judge, the state's reviewed this case and taken advice from other counsel at the CAC. In review of the case, what my colleagues stated is true. The alleged violation is there was internet streaming on his computer, so like Netflix. We're not on his computer, on his TV.
On his TV.
So we're going to dismiss the violation and ask for his probation just to be reinstated and complete all the terms of the probation. And we're going to dismiss the new law violation based on insufficient evidence to prove the charge.
We will, of course, not object to that, Judge.
All right, so just release him to finish out his probation?
That's correct,
Without entering
Judge.
some type of plea or anything?
No, Judge. They're dismissing the BOP and dismissing the new charge, so there's nothing to
All right,
enter
well,
a plea
he'll
on.
just be released today to complete it. Yes, Mr. Barry.
Your Honor, he's on GPS, so he can't be released. Our probation's asking that the jail hold him until...
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or
Calls
sell...
us when they're ready to release him, then we go out there. So I can't tell you when the jail's going to call us to tell us he's back and is ready to be released. But when they do, we will get out there.
All right.
Well, I'm assuming we're talking later today or tomorrow.
Right, yes.
Okay.
Yeah, later today, tomorrow at the latest.
Yeah. Okay. So he'll be released to just, once they get a GPS monitor on him, and just finish out his regular old probation, okay?
Thank you, Judge. Appreciate it. All right, so your case is over with, and you'll be out later today or tomorrow, okay? All right, call your parents when they tell you that you're free to leave, okay? So they can come pick you up. All right, Judge, I've got one left, Ms. Mayan
Who's this gentleman back here?
Oveda. Yes,
Mr. Patrick has showed up, Your Honor.
Mr. Patrick?
you want to go ahead and handle him?
Yeah. Is this Glendon Patrick?
Yes, Your Honor.
Okay.
Your Honor, in speaking with probation, he is re-enrolled in counseling as required. His probation time has run out, and I believe they're requesting to terminate.
Is that right? Mr. Barry, you want to terminate? He's ready to be terminated on probation?
He is currently in treatment and has been attending. The treatment is with the ECLC program,
Yeah.
and he's in compliance at
Okay.
this point. So
So-
we don't have any problem
Mr.
from our
Sprouse.
position terminating his probation.
State adopts probations.
All right. Okay. Well, terminate your probation and just stay out of trouble. You see what a problem, it's a hassle breaking the law, right? So don't do that. Thank you. Probation terminated.
Outstanding monies, we ask those go to collection.
All right.
Thank you, Your Honor.
Your Honor, there is also another person in the audience, Casey Sally. She is actually, I told her, she's on this afternoon's docket,
We'll take her now. if
and she's I have her as number 32 on this afternoon's docket.
32.
She's here for arraignment, Your Honor.
Casey Ann Sally, 2024 CF 891. You're charged with let's see, what is she charged with?
Attempted possession?
Attempted possession of controlled substance? What is this
Not
with?
what she's charged with. That was on on benchmark, but what she was charged with was actual possession.
Possession of controlled substance? Okay.
Yes, it was alleged fentanyl, and I'm aware of the defense to this crime. We're waiting on the FDLE report to get back, and if it's fentanyl, then we'll proceed. But if it's not a controlled substance, she's innocent, and I'll dismiss the case.
All right, we'll set her for June 24th.
Thank
Pled her
you, Your
not
Honor.
guilty.
Not guilty and request trial by jury.
Appoint public defender. Thank you. Hopefully it works out.
Say 27th,
Okay.
Judge.
24th, I think.
24th.
Pretrial conference.
Thank you.
I do, Judge.
And I'm ready on her when she's ready.
Judge, I'd communicated with the state attorney. I don't know if he got the email. I was asking him to clarify what the offer was.
Yes. The offer, if I'm not mistaken, is a credit for time served offer, but this is,
Is this Miss Mayan Ovida?
It is, Judge.
All right.
yeah, so it would be reinstate the probation,
Okay.
but to admit to the violation and reinstate.
You want to admit you violated probation, I'll reinstate you to probation, finish it out.
Is that what you want to do?
Yes, sir.
Okay, that's
Would
what
you
we'll
raise your
do,
right
Judge.
hand to be sworn? Ma'am, you swear the testimony you give for is course of truth, so help you God? This is State of Florida versus Ashley Mayan Ovida, 22 CF 2836. You want to admit that you violated probation? Are you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? You under the influence of any drugs or medication that prevents you from knowing what you're doing here today? You happy with the work Mr. Williams done for you on your case? Court finds admission freely and voluntarily entered. Court accepts it, will reinstate probation, finish out the original terms.
Thank you, Judge.
Thank you.
All right.
May I
Judge,
approach with the score sheet, Judge?
And, Your Honor, from probation standpoint, just to prevent us from coming back in a month, her scheduled termination date is July the 24th of this year. She has some outstanding monies. If we can just go ahead and get those put to collections at this point,
Yeah.
then we won't be coming back in a month.
All
Say
right.
She didn't pay the money.
Okay, we'll do that. Change it to collections.
Thank you.
And that's how I figure out what it's going to be.
Morning, Your Honor.
Good morning. All right. We got Bobby Joe Booker, 23 CF 388.
You'll get out today. Yes, Your Honor. She is signing a plea agreement where she will be admitting a violation. It's a credit for some time served sentence. We've previously gone over the agreement, and I will, if I may approach. Thank you.
Ms. Booker, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God? You want to admit that you violated probation? Are you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case? Court finds admission freely and voluntarily entered. Court accepts it. Adjudicate you guilty, revoke and terminate probation. Sentence to credit for time served. 100 VOP cost of prosecution, 150 cost of defense. All monies to be paid within 180 days, release from jail, then to collections if not paid. Okay? Thank you. All right.
Yes, this is Talia Derm. Your Honor, we're set for a bond hearing today, but I would like to withdraw that motion for bond. We've reached a global resolution
All
with the
right.
state in 24 CF 1026, 24 CF 1108, and 24 CF 594. Those are not all on the docket, but those are all her open cases. Currently, we have gone over the plea agreement. She's just going to sign. I may approach.
All right. You are Talia Durham.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God? State of Florida versus Talia Durham,
Your
24.
Honor, if I may, for the record, I am still appointed to Ms. Durham on 2 of those case numbers. We did withdraw previously to RCC. I would just move to, for the PD to be relieved and RCC to be appointed for this plea,
All right.
just for the record.
I'll remove the public defender and appoint to RCC. Was she appointed just for one of these cases?
We had previously found a conflict, and then she had gotten the other 2 charges since I believe she was arrested on the first case, and we hadn't caught the conflict in time to get all the 3 cases to RCC, but Ms. Flowers has done such an excellent job getting this case resolved. We'd asked to be relieved and RCC appointed.
All right, I'll relieve you and relieve the public defender and appoint RCC for
Thank you,
this
Judge.
plea. All right, so it looks like she's pleading to these charges. There's no lesser included that I can see. Is that right?
Pleading as charged.
All right. Ms. Durham, you want to enter a no contest plea in 24 CF 1026, possession of controlled substance, a 3rd-degree felony, possession of paraphernalia, 1st-degree misdemeanor, possession of marijuana, 1st-degree misdemeanor. Those 3, and in 24 CF 1108, you want to enter a plea of no contest to smuggling, contraband, and possession of a controlled substance, both 3rd-degree felonies. And at 24 CF 594, you want to enter a no contest plea, possession of controlled substance, a 3rd-degree felony. Correct? Did you read and sign this plea and sentencing agreement form?
Yes,
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your cases? Court finds the plea is freely and voluntarily entered. Court accepts it. 24 CF 1026, count 1, judge guilty, 2 years drug offender probation, wear a GPS monitor, $1 per day. Weekly UAs, enroll in substance abuse treatment and complete. 515 court costs, $150 cost of defense. Curfew 7 p.m. to 7 a.m., which I'll allow probation to adjust for work purposes. Counts 2 and 3, a judge guilty, 11 months, 29 days probation, concurrent with each other and concurrent with count 1. In 24 CF 1108, count 1 and 2, a judge guilty, 2 years.
Drug offender probation, Your Honor.
Okay, drug offender probation concurrent with each other. And this is concurrent with count with the 24 CF 1026, 515 court costs, $150 cost of defense. 24 CF 594, count 1. You are sentenced to a judge guilty, 2 years, drug offender probation concurrent with the other 2 cases, and 515 court costs, $150 cost of defense, waive cost supervision. All cases are concurrent with each other and each count. Adjudicated guilty on all cases, all counts. Okay? Thank you.
Your Honor, that's weekly UAs?
Yes, weekly UAs.
And GPS is to be hooked up prior to her release from the Okaloosa County Jail.
Yes. 24 CF 370, State versus Robert Woolery.
Thank you, Your Honor. If I could just have one moment to convey. Just want to make sure. Okay, Your Honor, we've reached an agreement with the state. This is a plea to a misdemeanor, so it won't have a score sheet. We've previously gone over the plea agreement, and I'm just going to have Mr. Woolery sign, if you understand. Sorry, it's kind of hard.
You can borrow this table if you need to.
Yeah. Yes, sir. Data for you. May I approach?
All right. Mr. Woolery, would you please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God? You want to enter a no contest plea to the lesser charge of simple battery, a misdemeanor. You understand that?
Yes, I do.
You can put your hand down. Are you aware of the rights you're waiving by entering this no contest plea? Are you aware of your rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Have you been forced or threatened to? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Your Honor.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. You charged with this was to a simple battery misdemeanor plea is what he pled to. You're judged guilty, 30 days jail with credit for time served consecutive to sentence in 23 CF 2046. Is it 161 or 767 court costs?
767, Judge.
767 court costs, $150 cost of defense, all money to collections. Adjudicated guilty. Okay? Thank you.
Court costs?
They're just.
You just pay those court costs as you can, okay? Thank you.
Okay, yes,
Thank you. Okay, take care.
all right, thank you, ma'am.
He's was substituted counsel in my other case, Mr. Williams, so.
Oh, sorry, excuse me, so
Thank you. Thank you, Judge.
So, 1129 Okaloosa County Jail, credit to begin upon date of last BOP arrest. Probation, $100 cost of prosecution on each case, $100 public defender fee on each case, $50 application fee. We've reached an agreement in this matter, Your Honor. She's just going to sign it at this time. If I may approach, Your Honor.
This is 2018 CF 86, 2019 CF 214, State versus Rosemary Patricelli. Would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God? Ms. Patricelli, do you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it, adjudicates you guilty. 11 months, 29 days, Okaloosa County Jail. Credit to begin upon date of last VOP arrest. Revoke and terminate probations. $100 cost of prosecution times 2. $100 PD fee times 2. $50 PD application fee on 19 CF 214. Okay?
Thank you.
I'm ready.
All right, we'll do some, Mr. Gibbs has a appointment he's got to get to this afternoon, so.
Yes, Judge, and I was not able to reschedule it. It's an important appointment that I need, Judge.
I got you, all right. Well, so these are arraignments for this afternoon, we're doing them early.
Yes, Your Honor, thank you. Judge, first I have here Mr. Christopher Arnett. This is 24 CF 977.
What number is he on the docket? Okay. All right, charged with possession of an firearm or ammunition by is this by a convicted felon? Is that what his charge is?
Yes, Your Honor, that's his charge. Judge, we'll enter a not guilty plea for now, and if we can just leave this up for June 24th, and we'll see if we can get it resolved by then.
All right, thank you.
Your Honor, Tim Gibbs on behalf of Mr. Everett Booth. Judge, this is 24 CF 864. Judge, he also has 23 CF 2118, which is a VOP.
All right, on 24 CF 864, he's charged with domestic battery by strangulation.
Judge, we'll enter a not guilty plea at this time and leave this set for pre-trial.
All right, June 24th.
Thank you, Judge.
Thanks, Judge. My apologies. Did we set it for a VOP hearing?
What date would you like?
The 27th.
June 27th.
June 27th for a VOP.
Next one is 24 CF 967, State versus Kizzy Campbell.
Yes, Your Honor. Tim Gibbs on behalf of Ms. Kizzy Campbell. We have reached an agreement, if I may have her just sign the agreement. Advertisements, okay?
Yes, sir.
All right. So I just need you to sign right there for me, please. This takes care of it. We're not going to file it or anything like that after this plea, okay?
Thank you.
5:30. If I may approach, Your Honor. Concluded, no objection.
Ms. Campbell, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, I do.
All right, thank you.
You're welcome.
Did you want to enter a no contest plea to possession of controlled substance, meth, a third-degree felony, possession of paraphernalia,
Yes.
2 counts of possession of paraphernalia, both first-degree misdemeanors, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty on all counts, sends you to time served on all counts, $100 cost of prosecution, $515 court costs, $150 PD fee, all due within 180 days or sent to collections.
Yes, sir.
Thank you, Judge.
Okay?
Good luck.
Thank you.
Your Honor, next I have Ms. Wanda Carpenter, Judge. This is 24 CF 909, 24 CF 1124. Your Honor, we'll enter not guilty pleas at this time and leave this set for pretrial.
This is Wanda Carpenter, 24 CF 909, charged with vehicle theft, third-degree felony. Oh, there's not? Oh. There's no information filed on this case.
There's no information filed, Judge?
There should be, Judge. It was either filed late yesterday or this morning.
It's not on the
Scheduled
docket.
for today. I'm not
Bring her
seeing-
back this afternoon, how about that?
That's fine. if we
And then
wanna
Ms.
do that.
Rivers can sit in for you.
She can, Judge.
Okay, we'll bring you back this afternoon. We got to have that on the docket, okay?
Yes, sir.
We'll bring you back this afternoon.
Thank you, Judge.
Thank you.
Thank you. Court appoints Ms. Rivers to represent Ms. Carpenter
At
on
least for this afternoon, Judge.
this afternoon.
Your Honor, Tim Gibbs on behalf of Beulah Galloway.
Galloway.
That's what you want to do.
23 CF 743, State versus Beulah Galloway. Charged with possession of cocaine, a third-degree felony, and narcotics possession, narcotics equipment possession. Is that a third-degree felony, too, or a first-degree misdemeanor?
First-degree misdemeanor.
First-degree misdemeanor, Judge.
Okay,
And we have reached an agreement, if I may approach, Your Honor.
all right.
Score sheets included without objection.
Ms. Galloway, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God? All right, you want to enter a no contest plea to possession of a controlled substance, cocaine, a third-degree felony, and possession of paraphernalia, a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir. Very satisfied.
Court finds the plea is freely and voluntarily entered. Court accepts it. On both counts, sentence you to time served, $100 cost of prosecution, $515 court costs, $150 PD fee assessed within 180 days or sent to collections.
Yes, sir.
No action on any and all failure to appears for this case.
Yes, sir.
Correct, State?
That's correct, Judge.
All right, and adjudicated guilty on both counts.
Yes,
Thank
sir.
you, Judge.
Thank you, sir.
Good luck.
Thank you.
Judge, the only other person that I think, well, he's on the afternoon docket, is Mr. Fernandez. I have him. Yeah, I have him on 3 other cases already. He's not been appointed on these, but we can address that this afternoon. He's already, I believe the court already filed an order to have him evaluated for competency. Yeah. we can
All right,
address
we'll
it.
bring him this afternoon. Okay, thank you.
Judge, can I recall Ms. Mayan Oveda?
Yeah?
All right. Mr. Berry reminded me that one of the conditions of probation was that she get an alcohol evaluation treatment. That's one of the conditions she hadn't completed. So they're going to have to turn around and re-arrest her on a new BOP because she's not going to have enough time to get that done. I've spoken with the state on it. The original offer was, like 6 months credit for time served. We're probably around there anyway. It turns out that she's got another case over in Alabama, and so they'll be addressing some of these issues there. The state's agreed to just call it time served, and we'll all move on with our lives and call it a day.
That's correct, Judge.
So, you want to withdraw her admission to?
Yes, sir.
And
There's
enter
a
a-
new admission with the stipulated sentence of time served.
All right, is that what you want to do? Ms. Maya Noveda?
Get out and go to the court.
You want to withdraw your plea and enter an admission to a time served sentence?
Sir.
Has anyone forced you, threatened you to want to withdraw your plea and enter a new plea?
No, sir.
And you're still waiving the same rights, you understand that?
Yes, sir.
Has anyone forced you or threatened you to enter a new plea with a time served sentence?
No, sir.
Are you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Cannot seem to find her. I don't know why. We just dealt with her.
It may be under O, Judge. I've got a copy of the docket. If you'll give me a second, I'll look at it.
Well, I thought so. It was the very last. All right, well, what I'm going to do is change her sentence to sentence to time served in the county jail, nothing
Yes, sir.
else. Okay?
Thank you, sir.
Outstanding monies to collections, okay?
Thank you, sir.
All right, thank you.
Good luck.
Thank you.
What else we got? Who? Anybody?
I don't have anything else, Judge. I
Who's
think
this
it's an issue we're going to
gentleman back in the back?
He's our county PD, Charles Hall.
Mr. Hall, you need to be appointed to some felony cases?
Actually, if we could just have him catch all of Gary's.
All of Mr. Hudson's cases, at this rate, he's his personal attorney.
All right, what else?
Can we approach about a pretrial detention?
We have that today, don't we?
Yes, sir. I've not been appointed on it as yet, but.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.